So first of all, I'm going to look at the current position in respect of tenants keeping pets in residential premises. Then I'm going to come on to the upcoming legislation. Within that, I'm going to look at firstly the Renters Reform Bill, then the Tenants Fees Act 2019 and the proposed amendments to that, and then the proposed Dogs and Domestic Animals Accommodation and Protection Bill. Then I'm going to move on to some of the areas of uncertainty that are around those proposed changes and proposed bills. Then I'm going to look at the new Model Tenancy Agreement, which is an agreement that's been introduced by the government recently. And then finally, I'm going to look at when and how the new legislation will apply. The tenant will be required to seek prior written consent from their landlord, who must not unreasonably withhold or delay their consent, and must consider the occupier's request on its own merits. And under the bill, a landlord can exclude animals if the owner does not have a vet certificate, or if there is one of the following. First of all, the owner is unable to care responsibly for the animal. Secondly, the welfare of the animal is threatened by being kept in the accommodation. Thirdly, that the animal is a danger or causes a private nuisance to other persons in the vicinity. And lastly, a landlord is able to exclude animals if they hold a certificate of exemption. So clause 1.5 also sets out that the landlord cannot charge a fee, but they can, as I've said before, require the tenant to take pet insurance, and in addition, they can request an additional reasonable amount to the deposit. However, that additional amount cannot surpass the current deposit cap requirements under the Tenants Fees Act, which stands at a 5-week cap where rents are under £50,000 a year, and a 6-week cap if over £50,000 a year. The usual deposit taken, I would say, is 4 weeks. So in reality, the landlord would only be able to take an extra week rent, or in the case of property at high value, an extra 2 weeks rent.